unavoidably absent. However, our esteemed participants are all logging in, and we thank you for joining us. Today is the 8th day of our 10-day training. Without much ado, it's my singular honor and privilege to share with you Chief Akiolujimi, CON, SAN's abridged profile. I wish I had all the time in the world to go through it, but I can tell you 2 hours will not be enough to tell you all that Chief Olujimi has accomplished. I'll keep it very short so that we'll dive deep into the business of today. Chief Olujimi, CON, Senior Advocate of Nigeria, was born some 76 years ago in Lageri local government of Ibadan into the family of late Pa and Mama Lasisi Olujimi. For his tertiary education, Chief attended Obafemi Awolowo University, Ile-Ife, between 1975 and 1978 and graduated in 1978 with second-class upper division. He proceeded to the Nigerian Law School, Lagos, where he obtained his BL in 1979. He was registered as a barrister and solicitor, called by 1979. Served at the Ministry of Justice in Ilorin, Kwara State between 1979 and 1980, at the end of which he got a meritorious and outstanding service award. He joined the law firm of Chief Are Afe Babalola SAN as a pupil counsel and worked there from 80 to 86, where he learned intensive advocacy. 1986, he started his partnership with late Sir Oluwarotimi O. Akeredolu, senior advocate, former governor of Ondo State government of blessed memory. After an intensive and distinguished legal practice, Chief was conferred the prestigious title as Silk in 1997. He was appointed Attorney General of the Federation and Minister of Justice 18th July 2003 and served in that capacity till July 2005. While in office, he contributed immensely in several aspects of national development, by reason of which he was conferred with the National Honor of Commander of the Order of Niger in 2011 by the then President Goodluck Ebele Jonathan. Amongst other things, Chief initiated a comprehensive program for the reform justice sector, which included revision of our laws, which led to the publication of the 2004 set laws of the Federation of Nigeria, as you all know. He worked with the Italian experts in setting up the National Agency for the Prevention of Trafficking in Persons. He attended United Nations conferences and several other led ministerial delegations. He did a whole lot during his stint as our Attorney General. He had several awards. Just to mention a few, he was awarded Commander of Great Ife in 2007, a Great Ife alumni. He was awarded by the Institution of Surveyors in Nigeria in 2016, and several others. Considering his many contributions and growth, he is revered and also has a lot of accolades from the Anglican Church, where he is actively committed. Chief has authored several papers, lectures, and delivered at professional gatherings, conferences, workshops, and other specialized arms of government, some of which include the law enforcement operations and fundamental rights issue, Finding a Balance. This was in 2007, Enhancing Transparency in Nigeria, amongst others. There's a whole lot. But Chief is married to Chief Mrs. Florence Olujimi. They are blessed with 5 children, 5 of whom they are blessed with children, 5 of whom are qualified as lawyers, and they are engaged in private practice. Ladies and gentlemen, I present to you Chief Olujimi Chief Olujimi, Senior Advocate of Nigeria, for the training today. As you can all see, I'm super excited. Today happens to be a masterclass session for us. Thank you so much, Chief. I hand over to you now.
Thank you, Mabel. Good afternoon. I'm very happy to be with you and all my learned colleagues this afternoon. I know you have had quite a number of lectures since this training program started, and you have learned quite a lot. What we are doing today has to do with appellate proceedings. When you have conducted your trial in the High Court and you're not satisfied whether you won or you lost, the next level is the Court of Appeal. And what I'm asked to do today is to talk to us on the art of writing appellant's brief, the art of writing respondent's brief, and the art of writing a reply brief. Now, there's no doubt that appellate proceedings is a very important part of litigation, and you have to ensure that you equip yourself with a good knowledge of the rules relating to appellate proceedings. Now, we have two levels of appellate proceedings. You have the Court of Appeal, then you have the Supreme Court. I do know that, of course, at the magistrate court level, you can also appeal to the High Court, but they are not dealing with writing of briefs there, so I'm not going there. I'm only dealing with appeals to the Court of Appeal and the Supreme Court. Now, the very, very beginning of the task before you as a litigation lawyer is to ensure that you get to know all the rules applicable to appeals, whether at the Court of Appeal level or the Supreme Court level. If you are not well grounded in these rules, you may just find that technically you are out of court. This is why it is very, very important for you to master the rules and ensure that when you are putting your papers together, you comply with the rules. Now, in regard to the Court of Appeal, the rules which regulate appeals there are: one, the Court of Appeal Rules 2021. You also have the Court of Appeal Fast Track Practice Directions 2021 and the Election Judicial Proceedings Practice Directions 2022. That is for the Court of Appeal. Now for the Supreme Court, you have the Supreme Court Rules 1985 as amended up to 2014. You also have the Supreme Court Pre-Election and Election Appeals Practice Directions 2023. Now, as I said earlier, my duty is to discuss the art of writing briefs with you. But the starting point really, when it comes to writing of a brief, is that the record of appeal must be ready, because the reckoning of the time for you to write your brief takes effect from the time you have been served with the record of appeal, whether at the Court of Appeal level or for appeals to the Supreme Court. So that's why I will just touch briefly on the record of appeal. Now, at the Court of Appeal level, if you look at under H, it has its own prescriptions regarding the compilation and transmission of record of appeal. In the Supreme Court of Appeals to Supreme Court, it is Order 7 of the Supreme Court rules that you look at, and that is for ordinary civil and criminal appeals. Now, the important point I want to make on the record of appeal is that you, as the appellant, have the duty to ensure that the record is prepared within time by the registrar of the trial court. And in appeals to the Supreme Court, you ensure that the registrar of the Court of Appeal gets the record ready within the stipulated time. If this does not happen, if you fail to do this, the respondent is entitled to bring an application for the dismissal of your appeal for lack of diligent prosecution. If you are lucky, within the time that motion is pending, if you have a good explanation, then you may find that your appeal is not thrown out. But if you don't have a convincing explanation to the relevant court, then your appeal may just get off the court's list and you may never be able to come back. Now, in regard to now the writing of the brief for the Court of Appeal, I have mentioned the Court of Appeal rules in regards to ordinary civil and criminal appeals. So once your record is ready, then you have 45 days from the time the record is served on you to write your brief. And the respondent, of course, has only 30 days within which to write the respondent's brief. Now, I mentioned earlier the Court of Appeal fast track practice direction. That practice direction requires that the appellant must file his brief of argument within 14 days of the transmission of the record of appeal to the Court of Appeal. The respondent shall file his own within 10 days from the service of the appellant's brief, and the appellant has the right to file a reply brief within 5 days from the service of the respondent's brief. Now, I referred to fast-track appeals. Now, the fast-track appeals relate to a number of specialized subjects. You have within the fold death appeals, tax matters, appeals pertaining to or connected with corruption, human trafficking, kidnapping, money laundering, rape, terrorism, then appeals relating to human rights cases, and of course those affecting prosecutorial or security agencies such as EFCC, ICPC, National Human Rights Commission, Intelligence and State Security Service. So all cases coming within that category, you must ensure that your brief is ready for the appellant within 14 days from the transmission of the record of appeal, and the respondent has only 10 days to serve his own brief after receiving the appellant's brief. And of course, as I said earlier, the appellant has 5 days to file a reply brief. Now, the next point to look at is what I categorize as content of a good brief. Because you don't just write anything, you must be guided by decided cases and the rules of court. Now, the rules of court, I'm starting with the Court of Appeal now, prescribe that in your brief, you must formulate issues for determination. Now, what is an issue for determination? That would be a concise statement of the complaint you have raised in the ground of appeal. Now it is possible that, let's say you have 20 grounds of appeal, a single issue may cover 1, 2, 3, or more grounds of appeal, depending on how you frame it. So this means it is very, very important for you to know how to formulate issues. And you can only get to know this if you make the practice of reading cases in our law reports, where you find, in many cases, the Supreme Court adopting issues formulated by either the appellant or the respondent, and they will say this has covered the issues effectively. So you can only learn from reading the law reports and get to see how issues have been formulated. We have quite a number of decisions rendered by the Supreme Court and the Court of Appeal on formulation of issues. For instance, you have Busari and Husseini, which is reported in part 237, page 557 at 580, paragraph D. You have Onia and Onya, 1989, One Nigerian Weekly Law Reports, part 99, page 514 at 527, paragraph C. I have quite a number of other cases on that, but you will help yourself tremendously if you make the practice of reading up decided cases by the Court of Appeal and the Supreme Court on formulation of issues, because you can throw yourself out of court if you have badly formulated issue. So you have to learn to formulate issues appropriately and properly from the grounds of appeal. Now, while formulating issues, if you fail to remember a particular ground, it is held that, oh, you have abandoned it. It may be out of an oversight, and it may be the issue that will really, the ground that will really sustain your appeal. So you have to make sure that when formulating issues, you ensure that all the grounds of appeal contained in your notice of appeal have been taken care of. Now, the brief itself is not at large, and that takes me now to the number of pages of a brief, the font and size of paper that is required, whether at the Court of Appeal level or the Supreme Court level. For instance, appeals in ordinary civil appeals, civil and criminal appeals to the Court of Appeal, you are required, that is, the appellant should not go beyond 35 pages, except where the Court of Appeal has directed otherwise. You must contain your arguments within 35 pages. And of course, the paper size required is A4. And the font shall be maybe Arial, that's your choice now, maybe Arial, Times New Roman, or Tahoma of 14 font size. and with at least 1.5 line spacing in between. Now, if you fail to comply with these stipulations, the registrar of the court is under a duty, as stated in the rules, not to accept your brief for filing. So that underscores the importance of you complying with the stipulations in the rules, so that because if you don't comply, that means you probably will go back home to start all over again. And in the process, the time within which you have to file your brief may have run out. And that means you now have to begin again by filing motion for extension of time within which to file your brief. Since it's not for the mere asking, you may not, in some cases, be lucky to get the Court of Appeal to grant you that kind of a motion, seeking to extend time to file your brief out of time. Now, I mentioned earlier fast-track appeals. In respect of the civil and criminal, ordinary civil and criminal appeals, I said your brief should not, whether you are appellant or respondent, exceed 35 pages. But in fast-track appeals, you have a different prescription. The appellant's brief should not exceed 15 pages in interlocutory appeals and 25 pages in final appeals. Well, the paper size and font are the same, as I mentioned earlier. Now, it is open to a respondent in his own brief to raise a preliminary objection against the hearing of an appeal. Now, when you look at Order 10 of the Court of Appeal rules, which provides for filing of preliminary objection, it is directed at the hearing of an appeal. So where your attack on the appellant's brief is not against the hearing of the appeal, but you are complaining about a ground of appeal or more grounds of appeal, what you are required to do is to file an application. That's a motion or notice urging the Court of Appeal, and if it's in the Supreme Court, urging their lordship to strike out the grounds or grounds against which you are complaining. The notice of objection which you should serve pursuant to Order 10 of the Court of Appeal rules is only, as I said earlier, when your complaint is against the hearing of an appeal. For instance, it may be an issue of jurisdiction which you want to rely on. It's not now an attack on a ground of appeal or more grounds of appeal, because if you attack one or more grounds, you may have other grounds left which are capable of sustaining an appeal. But where your complaint is about against the hearing of appeal itself, maybe it was filed out of time, it becomes incompetent, then you can take up that notice of objection, file it and serve it, and your arguments on it will be contained in your brief so that your opponent, that the respondent, can respond to it in his own, that's in the reply brief when he files it. Now, there is a facility provided in Order 9 of the Court of Appeal rules, which deals with what I call, or which deals with what is expressed therein as notice of contention. Now, this is a provision that is not often called into use by a respondent. A notice of contention is available to a respondent who, at the trial court, let's say he had raised 10 points against a case, and the trial court only considered about 5 of them. That means he has 5 other points left placed before the court which were not considered. Now, if the plaintiff has now appealed, or maybe it's a defendant who appealed, now when you get to the court of appeal, you can take advantage of this provision on notice of contention, but you are required to have served notice, that is a process or notice of contention on the appellant within the time stipulated, you see, in order 9 of the Court of Appeal rules. So if you fail to have served it, then you cannot raise any argument in your brief on the notice of contention. And it may happen that that kind of notice is what may sustain, you see, your win at the trial court. When that's at the Court of Appeal level, the grounds that the trial court had relied on may no longer be able to sustain your win. So that's why you should not just overlook this facility of notice of contention in an appeal to the Court of Appeal. That is when you are a respondent to an appeal. It can be your saving grace in some appeals. Now, this notice of contention, I should say straight away, is applicable only to appeals in the Court of Appeal. It was abolished in appeals to Supreme Court since 1985. So if you have such an issue not, for instance, decided by the Court of Appeal, which you raised, and there's now an appeal to the Supreme Court, you will need, as a respondent, to also cross-appeal if you want those points to be considered by the Supreme Court. Now, the notice, which that's on the issue of contention, the period allowed for you in interlocutory decisions for you to serve that notice is 15 days. And in any other case, you must serve that notice within 30 days on the other party. If you failed to, then you have not properly raised the issue of notice to contend, and that means you cannot argue it before either the Court of Appeal. I have said earlier, in the Supreme Court, you can only cross-appeal if you have points you raised in the Court of Appeal which were not considered, but which are material in an appeal to the Supreme Court. Now, again, I have referred to the case of Lagos City Council versus Ajayi, which is reported in 1970, All Nigeria Law Reports, page 293, at pages 296 to 298. You have a fuller discussion of a notice of contention in that case. So it will pay you a good dividend if you read up that decision. Now, how do you conclude your brief? You have provision in the Court of Appeal rules and Supreme Court rules on how you conclude your brief. Order 19 rule, sub rule 3, no, rule 3 and the sub rule 4 of the Court of Appeal rules says you must conclude your brief with a numbered summary of the points you have raised in the arguments and the reasons upon which the argument is founded. Now, sub-rule 5 of the same order says you don't need to set out the facts of the case in your brief. You don't need to summarize the judgments of the court. You also do not need to set out statutory provisions which are relevant to the appeal. And of course, again, the laborious exercise of including what happened in the trial court, you also don't have to put in the brief. It's sufficient for you to just summarize the arguments you have canvassed in the brief, in the concluding part of the brief. Now, I have mentioned reply brief in the course of my presentation. Now, a reply brief is available to an appellant in a situation where the respondent has raised a new point in his own brief, which, if it is not answered or responded to by the appellant, it may spell the end of the appellant's appeal. So it's very important to read carefully through the respondent's brief to see if he has raised any new issue not yet covered by the arguments you have canvassed in the appellant's brief, so that you can file a reply brief. Now, in regard to ordinary civil appeals in the Court of Appeal, the appellant has 14 days from the service of the respondent's brief to file his reply brief, which, as I said, should deal with only the new points raised by the respondent and also the preliminary objection raised, if any, by the respondent in his brief. We have several cases on that. But one other point on reply brief, which I should mention, is that even the respondent has a right to file a reply brief in a situation where, for instance, he raised preliminary objection which the appellant has responded to. If he has raised, that is, the appellant has raised any new issue in his response, the respondent is entitled to also file a reply brief to respond to those new issues raised by the appellant in his response to the preliminary objection. And for this, you have the case of SPDCN Limited versus Agbara, contained in part 1496 of a Nigerian Weekly Law Report, page 353, particularly at page 380, paragraph C to D, decided by the Supreme Court. Now, I have tried to put together during my discussion, appeals to the Court of Appeal and the Supreme Court. Now, the issue of font size and all that, which I have mentioned, also apply to appeals to the Supreme Court. The only differences you probably have to do with the number of weeks that the appellant should file his brief, which is 10 weeks, Then the respondent has 8 weeks to file his respondent's brief, and the appellant, of course, has 4 weeks within which to file his reply brief, if any. Now, I have been referring to ordinary civil and criminal appeals. Now, we have appeals in election petition cases. And for that, you have, for the Court of Appeal, you have a party direction, and the Supreme Court also has a practice direction on it. Now, in election petition appeals to the Court of Appeal, the appellant has only 7 days to file his brief of arguments after the receipt of the record of appeal, and his brief should not exceed 40 pages. The respondent, on the other hand, has only 5 days from the receipt of the brief of the appellant to file the respondent's brief, and the appellant has 2 days to file his reply brief. Now, the reply brief of the appellant should not exceed 15 pages, and of course, the font size, paper size, line spacing are the same as I have mentioned earlier. But in the Supreme Court, the appellant in election cases has okay, it's a reply brief shall not exceed 10 pages. That's the appellant. His reply brief shall not exceed 10 pages, which shall be filed within 3 days of the service of the respondent's brief. Now, the difference between the Court of Appeal and the Supreme Court in regard to this reply brief is that whereas the appellant has only 2 days in the Court of Appeal to file his reply brief, the appellant to the Supreme Court, in applicable cases, because it's not all cases that can go on appeal to the Supreme Court, you have the governorship cases, you have the presidential election petition case. Those ones can go to the Supreme Court. Senatorial and others end at the Court of Appeal level. So I have come to the end of this presentation, and I think we can now get down to questions.
Thank you so much, Leonard Silk. I must confess that I was writing and noting some things while you were speaking. And our colleagues here have questions. Questions are meant to be in the Q&A box and not in the chat box. It's easier for us to take your questions from here. I'll take the first one from Ugochukwu Okolotu. Says, thank you so much, Leonard Silk, for your time. Please, is it a must to indicate the grounds of appeal from which the issues are formulated in the brief of argument?
Repeat what?
Is it a must to indicate the grounds of appeal from which the issues are formulated in the brief of argument? Thanks again, Leonard.
Yes. Issues are formulated from grounds of appeal, and a respondent who has not appealed cannot formulate issues outside the grounds of appeal. He is bound by the grounds of appeal. And if he formulates any issue that is outside the grounds of appeal, that will be an incompetent issue, and the court would not countenance it.
Thank you,
So
sir.
that's it.
There are, I think the comments are in the chat for. Can more than one issue for determination be formulated from a ground of appeal?
More than one issue
For determination be
cannot,
formulated.
more than one issue cannot be formulated from a ground of appeal. It is expected that in the most of laborious preparation, you may decide to say, okay, I formulate an issue from each ground of appeal, but in proper presentation, an issue must cover, in most cases, more than one ground of appeal. So you have an issue covering grounds 1, 2, 3, and 4 together. Issue 2 may just cover maybe say ground 5. Then issue 3 may cover ground 6, 7, 8, 9, and 10. But you cannot have a situation, or you shouldn't let a grant of appeal generate more than one issue. In several cases, we found out by the courts. So you have to guard against that always.
Thank you, Leneso. EKD Wandu, where the pages are above what the rules stated, what will happen? Thank you for your wonderful presentation, Leneso says.
Thank you. You asked me a question.
Yes, he asked a question. He said, where the pages exceed what is prescribed.
The sanction is a striking out of the brief. We have a few cases where the courts have been very well disposed towards the feigning appellant or respondent, and they allowed the brief, particularly when it's an inconsequential one of maybe about 2, 3 lines in excess of the pages prescribed. But that doesn't stop the court, because it's a violation anyway. If it's only one line more than the pages stipulated. But in some cases, we have had the court saying, look, when it affects the name of counsel and the list of authorities which he has attached, they don't strictly form part of the brief of arguments. And so if those pages fall outside the stipulated pages, the court does not take them as a violation. But you have had cases where you have arguments spilling beyond the stipulated pages, and the court struck out the appeal. Now, in election cases, it can be very fatal because you can't come back. In ordinary civil cases, ordinary appeal, criminal appeal cases, you can come back if your brief is struck out. But in election cases, that's the end of it all. You can't come back. So you have to be sure you keep yourself within the stipulated number of pages, so you don't put your client in any jeopardy.
Shall I ask what your thoughts are in the event that counsel requires to seek leave to have additional pages? If it's possible, do you suggest it's done before or after writing excess number of pages?
Yes, if you have, for instance, formulated more than the number of pages, you can go to the court with an application, you see, to reduce to the required number of pages. That is not prohibited, but in election cases, you are taking a great risk because you don't have that time. Once you have exceeded the number of pages, I think it's a violation that may spell the end of the appeal. But in ordinary civil and criminal cases, there's that leniency that, the Court of Appeal and the Supreme Court, you see, they employ in dealing with such appeals. But election cases, you have to be very careful, though. Otherwise, you just get your appeal thrown out on that technical ground.
Thank you, Leonard.
Yes.
EKD, I think we've taken that. This is from Samson or Sandu. Leonard Silk,
Okay.
I'm so excited to drink from your well of knowledge today. In my own judgment, your lecture is the best so far. Please, can one use the same approach for preparing final written address to prepare appellate brief?
Yes. You see, in preparing final written address, you see, if you let these prescriptions of the rules in appeals to Court of Appeal and Supreme guide, you see, your preparation, it will tremendously help your case. But at that level, of course, you need to set out the facts, the brief facts, the essential facts of the case in your written address. If you bring that out there, because it's expected anyway, but again, in a brief form, you don't have to go and set out the entire facts. By the time you want to do all that, the number of pages you have to write, you see, your address, your written address, would have been exceeded. But there's nothing wrong with adopting the same format to guide the written address before the trial court.
Thank you, Leonard. Chibweze Odom says, can a respondent to an appeal who aligns with the submission of appellant and who filed no separate appeal file a brief of argument urging the Court of Appeal to allow the appeal and set aside judgment?
No, the duty of a respondent is to support the judgment in his favor. So he is not required to file a brief to say that. Because we have seen cases where you find a respondent doing a separate brief, and in the process, a few of them would even be attacking the judgment in their favor. So if a respondent has not appealed, he cannot file a brief and then in it be urging the Court of Appeal or the Supreme Court to allow or not to allow. So he can just keep quiet there, unless we're not opposing the appeal. It has no merit. And that's all you can say there. You don't have to file any brief to say that.
Thank you, sir. Jerry Onyechi says, what are other exceptions other than jurisdictional issues that do not require leave of court as new issues? Not very clear what he's saying. What are other exceptions other than jurisdictional issues that do not require leave of court as new issues? Not well framed.
I don't seem.
Yeah, maybe you should ask your
understand.
question again, Jerry. You didn't frame it very well.
Mm.
Japheth Opawale says, thank you, Leonard Silk. You've really done justice to the topic. May I humbly ask the circumstances under which the Court of Appeal or Supreme Court can salvage appellant appeal from being dismissed for failure to file the brief of argument timeously.
Well, this is a matter of discretion.
Discretion.
Yes. And they say in matters of discretion, no one case is authority for the others. So it depends on the panel that is sitting. A kindly disposed panel will allow just any excuse you give for the failure to file your brief within time. But the very strict panel will not even listen to anything you are saying. Your appeal is out of court, and that is it. And a situation that may arise, which once in a while we come across, is where the respondent, let's say his brief is struck out for one infraction or the other. Now you have only the appellant's brief standing before the court. Does that mean that the court will now proceed to give the appellant judgment straight away? No. They will still look at the appeal on its merit. So if it has no merit, they will still dismiss it. So you won't say because a respondent has not filed respondent's brief, then my appeal should succeed. There's nothing like that. Too. Nothing like that. Because you are complaining against the error of the lower court. You have a duty to convince the appellate court that indeed the lower court has committed errors in law. So that's why you won't have such a free right to victory where the respondent has failed to file a brief or his brief has been struck out for one infraction or the other.
Brian Eford says, thank you, Leonard. Can a respondent apply to strike out an appeal where the appellant only filed notice of appeal and after 7 months filed a motion for stay of execution?
You see, in these matters, we all have to be very vigilant. We must be up and doing. When an appellant merely filed a notice of appeal and the time within which the records of appeal should be ready, he did nothing. Because even though you have the register of the court preparing the record, you as appellant also have a duty to follow up. It's your duty. Because you fail to, the respondent is entitled to bring a motion to dismiss your appeal, even at the stage that you have only the notice pending, because you have not demonstrated that you really have interest in this appeal. Because if you are, you must make sure that the registrar of the trial court gets the record ready within time, and then the transmission of it, of course, you also follow it up to the Court of Appeal. And within time, you must file your brief. Now, where the court has dismissed your appeal for any of these violations, for instance, where you fail to file a brief, that's a final decision. You cannot get it set aside. No amount of plea you address to the Court of Appeal or the Supreme Court will sway them to release that appeal. It's gone and gone forever. But other violations, maybe the record is not ready, you can, of course, move the court, to grant you time, extension of time to get the record ready. That can be done. But once the record is ready, the duty is now yours to show everybody that you indeed are ready to prosecute this appeal, and you show that by getting your brief filed. So where you failed to file the brief, in fact, the court can so much dismiss an appeal where you have failed to file your brief within time. So it is properly, within the right of a respondent to bring an application to dismiss an appeal when the appellant has shown that he's not really interested. And he shows that by his failure to take steps the rules require him to take in regard to the prosecution of his appeal.
Thank you, Leonard. Another anonymous attendee says, do you need the leave of court to file a respondent's reply brief where new issues have been raised in an appellant's brief?
Oh, a reply brief.
Where new issues have been raised in an appellant's brief.
You don't need any leave to respond, you see, to new issues raised by the respondent. Your right has been provided for in the rules. But if you are out of time in filing your reply brief, in ordinary civil and criminal cases, yes, you can apply to the court for extension of time to file that reply brief. But in election cases, I think the door is closed. Once you are out of time, the door is closed against you.
Thank you. Can an appeal be brought against a judgment or an interlocutory decision, which is about 3 years old?
Yes, again, it's a matter of discretion for the court. I'm aware that in the past, in some cases, the Supreme Court had had arguments and they had reserved judgment in the appeals. Then suddenly, one of the parties came with an application to reopen the arguments. They had adjourned for judgment. Then one of the parties came with an application to reopen the proceedings for additional arguments to be canvassed. Later, Chief Rotimi Williams did that in some cases. And there's nothing preventing you today from doing the same thing if you have a situation where the court, as I keep saying, in ordinary civil and criminal cases, because election cases are on their own, say they are sui generis, you cannot get that done there. But in ordinary civil and criminal cases, there's nothing stopping you. When you discover that after the court had adjourned for judgment, you probably now stumble on an authority that is very, very relevant to the issues canvassed, and you know that this authority has not been raised in the pending appeal for judgment. So you can now apply to the court to reopen the proceedings. And once you are able to convince them that, yes, this authority you are bringing will be of tremendous assistance to them in deciding this appeal, they will allow you to reopen arguments on the appeal. So it's happened before. There are precedents for that. You only need to read up all these cases, which of course are available in the law reports.
Thank you, Leonard. In a situation where the respondent brief in election tribunal has not raised new issues, can the appellant continue with the process or still need to reply?
No. The facility of reply brief is designed for attacking new issues, for responding to new issues raised by the respondent. So you are not under obligation to file a reply brief when, after you have read the respondent's brief, you find that he has really not said anything new, but has only responded to your own arguments. So his response to your arguments cannot constitute new issues, which you have to respond to. No. And if you look at several decided cases, you find that issues have been taken against reply briefs by respondents that, look, I have not raised any new issue in my brief to justify the appellant filing a reply brief. And the court, in many cases, have looked at such contentions and have overruled the reply briefs filed in such appeals.
Olusegun Ikuforiji, where leave to appeal ought to be sought and is not sought before appealing, what is the effect of such an appeal? Can leave be sought afterwards?
Ordinary civil and criminal cases, these latitudes are provided for. That is seeking leave of the court, the Court of Appeal, the Supreme Court, you see, to file, to appeal out of time and all that, or file your brief out of time. So when we are talking of whether you can do this and all that, let us appreciate that election cases are on their own. And what we are saying in regard to these issues of discretion don't really apply to election and pre-election cases.
Thank you, sir. My question is, in formulating grounds of appeal, is it mandatory prescription to distill issues for determination from the grounds of appeal formulated, and failure to do so, what is the effect? I think this has been
No,
answered.
if you fail to formulate an issue from any ground of appeal, the court holds that that ground has been abandoned. And sometimes it may be out of oversight that you have not formulated an issue from a particular ground of appeal, or it may be a deliberate thing. That's when you yourself have reconsidered the judgment you are attacking, and then you have considered relevant authorities, and you find that, oh, the the judgment, in fact, has dealt with this issue. I don't think I need to complain, having regard to the authorities which are now aware of. So you can abandon a grant deliberately in that manner. But if it was an oversight, just too bad. If it's in election cases, but in ordinary civil and criminal, you can apply to the court to amend the issues and the arguments you have put in your brief.
Thank you. This is another one from Ikuforiji.
Yes.
In what cases can one appellant be asked file separate notices of appeal?
Well, an appellant is entitled, when you are still within the period for filing notice of appeal, for instance, the second day after the judgment, you can draft grounds of appeal. Now, when you have the judgment of the court before you, you now find that in the first notice you filed, you have only put down 2 grounds of appeal. Having read the judgment, you now know or find that you can increase your grounds to 6, to 7, to 8, to 9. So you are still free to file a second notice, to file a third, to file a fourth. That's to bring in additional grounds as you come across them while reading these judgments. But you can only do that within the time allowed for the appeal without having to seek the leave of the court to file these other grounds. But once you are out of time, you have to apply to the Court of Appeal, or if it's at the Supreme Court, for leave to file additional grounds of appeal. And of course, when you now have 2, 3, 4 notices before the court, you base your brief of argument on the particular one that you want to rest the appeal on, and that the arguments you now apply to withdraw other notices, or you can even in the brief of argument indicate that the notices filed on so date, you are planning to abandon them, and you are basing your arguments on only the one filed on a particular date. So that's what you do. But you are free to file as many as occur to you within time, and outside time, you do so with leave of court.
Thank you so much for the presentation, sir, says Stephen Wani. On appeal, it is said that there is usually no call of evidence. Don't you think that this might occasion a miscarriage of justice in some situations?
No. You have provision in the Court of Appeal rules and the Supreme Court rules for you to move the court to lead additional evidence in the Court of Appeal and in the Supreme Court. Now, you have specific rules that guide, in considering such application, the grounds the court will consider include whether that evidence you want to bring at that level is material to the issues in controversy, and whether it was with reasonable diligence available at the time of the trial, but you failed, to get that evidence before the court. So if it was available, but it was out of your own failure to get the evidence before the court will not grant you that latitude to now call this additional evidence at the appellate level. But they have in several, the Court of Appeal and the Supreme Court have in several cases granted the applications to call additional evidence at the appeal level.
Thank you, Leonard Silk. It says where judgment is delivered and followed up by an after judgment ruling, when an interested party wants to appeal against both, where can the interested party seek leave if the interested party is out of time in appealing the main judgment, but within time in appealing the ruling?
Ruling? Which ruling is that? Which ruling do you have in mind?
That's because if there's a judgment, then the cause becomes firm to sufficient.
Yes, if you're an interested party, you want to appeal a judgment, and you're out of time, you have to go to the Court of Appeal, or if it's at the Supreme Court, you have to go to Supreme Court.
Can an interested party be out of time, Leonard?
You cannot be, because the provision allowing you to appeal as an interested party, it doesn't prescribe a time limit for you to be an interested party. So when you are now taking your application before the Court of Appeal, you first seek leave to appeal as an interested party. That's not limited by time. That is that particular prayer. But the appeal itself, which you ought to have filed within 3 months or say 1 month, you are now out of time. You now have to seek leave, to appeal out of time, then extension of time to file your notice of appeal, what we call the Trinity prayer. But if you are not a party, you see, to the appeal, just an interested party out there, then that initial prayer of the court granting you leave to appeal as an interested party, then the extension of time within which to appeal, to apply for leave to appeal, then the extension of time, you see, to file your notice of appeal. So you have 4 prayers going down the line there. If you are an interested party and appealing out of time.
Thank you, Leonard. If you notice, we're 12 minutes past 4. I've been trying to push all the questions. You've answered 16 so far, and I have 19 questions that you haven't answered.
Okay. Hey, you have so many.
We have so many, Leonard.
Yes.
And do I take a few more? How much more time do you want to spare us? I would imagine.
Can we grant 15 minutes more?
Very well. Thank you, Leonard. Rahim Election Lawyer says, who can file notice of contention and when can that be done?
Yes, it is the respondent to an appeal who can file notice of contention. And you do that after you have been served with the notice of appeal of the appellant, because you must put him on notice that you are going to rely on some grounds which were not considered by the lower court, but which are very material to a decision in the appeal. And yes, you do so in interlocutory appeals within 15 days, and in final appeals, you do so within, that is in any other case, as they put it, within 30 days.
Thank you, sir. Well, are there circumstances under which motion for extension of time will not be procedurally permitted before the Court of Appeal?
Well, again, you see, in matters of discretion, so you are not just relying on good luck, so to say. If you are lucky to be before a panel that is very well disposed, see, towards such applications, then without any, even when you find the respondent to the application making an argument, they say, look, how does that affect you? Let us deal with the substance. We are granting this application. What do you do? So it's a matter of discretion, really. And the court will decide when to grant and when not to grant. In such cases, previous authorities don't really help. They only guide, but they don't bind the court.
Emmanuel Onyejika says, thank you, Leonard, for this invaluable session. I have a question, not regarding brief of argument, but on effects of a conviction, on a plea of guilty during trial. Can a party who was convicted upon appeal of guilt at the trial court successfully appeal such conviction? If yes, I would be glad to be blessed with the exceptions.
Okay. You see, a man who pleaded guilty, if he had no counsel in court when he did, and at the end of the day, he now finds that a counsel can help him, then he can appeal. The fact that he pleaded guilty will not be a reason to deny his appeal. A litigant who had a counsel during the time that he pleaded guilty, he would have done so with the advice of his counsel. Now, appealing against the conviction may be a bit difficult, but he can appeal against sentence.
Thank you.
So, yes, he can appeal against sentence if
Thank
he had
you.
counsel in attendance at the time he pleaded guilty to the charge.
Thank you. Please, in mediation proceedings in the Court of Appeal, Mediation Center, how do you argue points of law that relates to jurisdiction of that is your only ground of appeal? If that is your only ground of appeal in your appeal before the parties was referred to mediation.
Mediation cases. Usually what you try to do there is to see how you can reconcile and resolve issues for the parties without the paraphernalia of hostile proceedings. Counsel can talk to themselves. The judge has awarded 20 million naira in this case. Now, I can speak to my clients not to appeal the judgment, but can we offer you, say, 10 million naira as a full and final settlement? If the parties agree, then you only now have to report back to the court that, oh, we have resolved this matter between ourselves, and we urge the court to make it the judgment of the court. You don't go there to begin to argue issues of jurisdiction and all that again. It's a platform for parties to talk to themselves, you see, amicably. It's not one where you go to begin to cite sections also of the Evidence Act does not permit this and that. You must talk to yourselves, you see, openly and with a mind to settle. You can resolve several matters in that manner. And of course, again, it takes two to settle. You cannot, by the compulsion of the other side, come to settlement. If you don't want to settle, then you just opt out of that mediation provision in the rules. And the court will hear you, you see, properly on your matter.
Thank you, sir. Where an appellant filed a motion for extension of time to compile record and save is pending, is it a reason why the appellant should not file brief until the court grants his application to regularize the record? Abdulrazak Olati.
Yes, you see, an appellant must always, you see, at all times, show due diligence. When you are applying for extension of time to file your brief, you are better able to convince the court that you are serious with your appeal if you have the draft brief ready attached to your application. Because if the records are ready, you're only out of time, I cannot see the justification for you to still continue to be out of time in getting your brief ready when the application you are filing today may not be hard within the next 2 or 3 weeks. So what you should do is get at least your draft brief ready. Let them see that, oh, the brief is in fact ready. but I'm only out of time by so many days. And this is why I'm applying for extension of time to file the brief. And of course, when they see that, oh, the brief is even ready, they will easily grant your application.
Thank you, sir. Victor Boji, what is Leonard Silk's view on seeking deeming orders?
Deeming orders. Yes, deeming order is just when you have your process ready and you have filed it separately from your application, you can pray the court to deem it as properly filed. But there are processes you cannot deem as properly filed except the court, in its discretion, decides to waive compliance. For instance, if you are applying for extension of time to file your notice of appeal, you don't deem the notice as properly filed because if the appeal court grants you that leave to file your notice of appeal out of time, you will still have to go and file it in the lower court. So that's why you cannot deem it as properly filed when you are before the Court of Appeal. The notice will have to be filed in the lower court where the record for the appeal will be prepared. But if you are already before the Court of Appeal or Supreme Court and you are amending your notice of appeal, then you can also include a prayer, see, to deem it as properly filed because the records are already before the Court of Appeal and you don't have to go and file it again in the lower court. You file it before their lordships of the Court of Appeal or the Supreme Court. In that case, you can ask for leave. Another deeming it as properly filed before the Court of Appeal or the Supreme Court, whichever applies.
Thank you, Leonard, for allowing us to tap from your wealth of experience, says Zainab Atoba. Please, where an appellant files a notice and brief with mixed law and facts without leave, how can he remedy the situation, sir?
All he has to do when he becomes aware that the grounds of appeal he has filed raise issues of mislaw and facts, or he has a doubt, because many a time you play behind that canopy of a doubt and apply, even when it appears clear, you apply to the court for leave to appeal on grounds of mislaw and facts. Now, that's like testing the waters in most cases. Once you have raised it before them, their lordship, they say, well, we don't see anything in this grant that looks like mislaw and facts. So we don't not going to grant you leave because this is purely a grant of law. Of course, you now say, well, my lord, because you have held in some cases that in case of doubt, we should apply for leave. This is why I'm here. And I thank your lordship for now holding that I don't need any leave to apply to argue these grants. That has saved you. You won't now have the respondent coming at the hearing of the appeal to say, oh, the grant of appeal raised issues of mislaw and the facts. But when you are in doubt, it's advisable for you to apply for leave to appeal on grounds of mislaw and facts. In many cases, it's not even easy to determine whether your grant of appeal raises issue of mislaw and facts. Issue of jurisdiction, that is well settled. That is always, it doesn't require or involve any issues of facts, issue of jurisdiction. So that one is always, but there are cases where you are taking a decision, you are picking on what the lower court has said, and you cannot really see whether it involves or raises issues of mislaw and facts. So it's better in such cases to apply to the court for leave, see to appeal on grounds of mislaw and facts.
Thank you. Ugochukwu says, please, what is the next line of action for an appellant in an interlocutory ruling whose motion for stay of execution has been refused by the lower court, while the said lower court has not heard the appellant's motion for leave to appeal?
Well, ordinarily, when you have a motion pending for, let's say, before the High Court, you have lost a case you are appealing, you also are applying for stay of execution. Now, in most cases, properly considered, that motion for leave to appeal and your motion for stay of execution should both come together and heard the same day by the court. Now, if the court refuses to stay execution and it grants you leave to appeal, then file your leave to appeal and now refile the application for stay immediately before the Court of Appeal. Or if the court refuses leave, all you have to do is file another application before the Court of Appeal for leave to appeal, and also file a separate application for stay of execution. In most cases, what the appeal court will say is, well, can you get your record ready? We want to hear the main appeal. We don't want to waste time on a motion for stay of execution. Get your record ready and then come before us to argue the appeal. Now, even when they don't grant a formal stay of execution, I don't expect a respondent in disregard of that guidance from the Court of Appeal to resort to execution. That would be an abuse of court process for which the Court of Appeal, they can't take some action against their counsel because they would, in the course of hearing that kind of application, will say, well, we don't expect that anybody with the appeal pending before us do anything funny under that judgment. So usually the respondent will not do anything. You would also have to wait. But the duty is on you as appellant to ensure that the record is ready within time and then your brief is put before the court.
Thank you, Leonard. I'm trying to find that one last question because it is 4:30.
Okay, look for it.
Our Q&A is inundated. Leonard, we've answered 24 questions. We have 18 unanswered, and we do apologize for our participants. Thank you for always showing up. But as you can see, we're constrained for time. We can't take all your questions. Yes. I'll take this final one. Okay, this last one, Ahmed Hilani. What happens if it is discovered that there is an error, perhaps an alphabet, in the name of the defendant or a respondent in an appeal?
It's only a little error which should not affect the substance. I remember I had taken an objection at the Supreme Court level in an election matter. You know, I was representing the All Progressives Congress. Now, the appellant in that case named my client as All Progressives Party, which was an error. Then I filed objection against the competence of the appeal because the party was wrongly named. No such party featured in the proceedings. So my argument was that, well, this strange name they have introduced into the appeal should nullify the appeal. Of course, the Supreme Court took a stand against my arguments and said, no, this is just a
Normal.
minor mistake that has nothing to do with the substance and the merit of the appeal. And of course, they just ignored it and overruled me on that. So that kind of error cannot be shaped, the competence of an appeal. And of course, if you are aware of such error, you can apply to correct it before the hearing of the appeal. But if it's sprung on you at the hearing, maybe you have not noticed it all along and the respondent kept quiet, he thinks that is a joker to use against you at the hearing of the appeal, it may not work that way at the end of the day for the respondent.
Thank you so much, sir. I will join my colleagues to re-echo once again our profound appreciation and gratitude for your time. You've graciously acceded, obliged us an extra 33 minutes of your precious time. Thank you for sharing with us from your wealth of experience. On this side from the MBA ICLE, we're profusely grateful for your time, for sharing your experience, expertise. We saw the way by which you navigated through the sessions, drawing the nuances from different acts of appeal, both at the Supreme Court, the Court of Appeal, the nuances, election tribunal appeals, the normal civil, the criminal. We've taken questions outside the scope of your subject this evening, but yet you have graciously answered all our questions. We're thankful to you so much, sir, and we're appreciative of your time. Thank you so much. And to our colleagues, thank you so much for inundating us with questions. You make this worth our while all the time. And we wish you all a very good evening.
Thank you, Mabel. I want to appreciate you. You've done perfectly well, exceedingly well. And I want to thank my learned colleagues for their very robust response, you see, to this subject we discussed. There's no doubt that you have demonstrated this desire, you see, to learn. And that's the best way for us, you see, to grow in this profession. When we engage together like this, you should always feel free, as you have done today, to raise questions. And the fact that you are even able to go outside the realm of the mandate given to me shows your readiness, your interest, and desire, you see, to grow in this profession. So I want to wish you all well. Thank you all.
Thank you, Leonard.
Thank you. Bye-bye.
Bye-bye, sir.
Bye. Thank God this thing didn't